So we have the militarization of police departments in the United States as hundreds of millions of dollars worth of military hardware is being given to them or sold to them at huge discounts by the U.S., by the Pentagon, so that they can cycle more and more giant goodies from defense contractors through the Pentagon so that the military-industrial complex in the United States can make more money. And we have our police forces becoming more militarized, number one. We have number two, at the same time, John McCain and Joe Lieberman proposing legislation that would allow the U.S. military not just to operate in the United States, which is now technically legal since the Bush administration did away with the 100-year-old, actually 130-year-old Posse Comitatus law that ever since the end of the Civil War had banned the U.S. military from ever again turning their guns on American citizens. That's gone. And now McCain and Lieberman have come out with a law that says that the president, at his discretion, can designate anybody in the United States, citizen or non-citizen, an enemy combatant, and have the military show up and take them out and put them in a military prison where they can be held in detention without trial, without a lawyer, with nothing, no due process of law, forever. Tell me it's not getting crazy. Now, there have been some pushbacks on this. I mean, these are fundamental violations of the Bill of Rights. One of the elements of the Bill of Rights, the Fourth Amendment, explicitly says that your home, your personal articles, personal effects cannot be subject to search unless there is a reasonable suspicion that is supported by a person under oath saying that a crime has been committed. And so there's reasonable grounds to believe that a crime has been committed. And yet, during the Bush administration, and in fact, there's a law to that effect that has to do with wiretapping, which, arguably is part of our personal effects and papers. The modern-day equivalent of old letters is your email, and your telephone calls. And during the Bush administration, even though there was a law in effect, there was then, there is now, that says that if they're going to wiretap you, they have to get a court order. They have to have a search warrant, essentially. That the Bush administration went ahead and wiretapped probably millions of Americans, certainly many organizations and people, illegally, and bragged about it. So a week or so ago, I guess it was a week ago Wednesday, Chief U.S. District Judge Vaughn Walker of San Francisco, in a case brought by the Al Haramain Islamic Foundation, which was based out of one of their two U.S. offices was here in my state of Oregon, ruled in this case. John Eisenberg is on the line with us. He is a lawyer with EANDHlaw.com is their website, with a San Francisco law firm that represented the Al Haramain Islamic Foundation. John, welcome to the show.
Thanks, Thom. It's great to be on your show.
Glad to have you with us. Now, first of all, just to set the stage here, Al Haramain may have been bad guys, if I'm reading this right. I mean, the United Nations lists them right now on the list of organizations associated with Al Qaeda in their official publication.
In 2004, the U.S. Justice Department declared that Al Haramain was funding Chechen rebels.
Right.
Al Haramain has been fighting that determination ever since, in a separate bit of litigation going on in Oregon.
But my point is that this group, if this was done legally, there might be some justification to go to a judge and say, hey, it looks like these guys are actually supporting terrorists. Give us a search warrant so we can listen into them. And had it been done legally, probably you never would have been brought into this case. But the fact of the matter is that George Bush said, I don't need no stinking warrants. We're going to listen in.
Oh, absolutely. If the Bush administration had sought in 2004 to get a FISA warrant for Al Haramain surveillance, they would have gotten it. Those warrants are very, very easy to get.
Right.
They chose not to attempt to do so. I said in open court a number of years back, and continue to repeat, that the Bush administration did not refuse to follow FISA because they had to. They refused to follow FISA because they wanted to.
Right. And there's a bizarre catch-22 in this story, John Eisenberg, and that is that you were able to argue this in court successfully, whereas the case, for example, that in Detroit about a year and a half ago that went before Judge, as I recall, was it Anna Diggs Taylor? Was that her name?
Yes.
Where she just ripped Rumsfeld and company and Cheney a new one. I mean, that ruling just had some really, really strong language in it, which again was another Islamic charity, as I recall, that had been illegally wiretapped by the Bush administration. That case got overturned on appeal because there was classified information, government information that was used against the government, and the government argued, you can't use our own information against us. We can refuse to give it to you. And so that case got thrown out. Yours was able to proceed, unlike most organizations that might know that they were wiretapped, but they don't have proof of it because this story, well, let me let you tell the story. There was a Pentagon official, wasn't it, or somebody who was bragging about this?
Well, let me back up a bit and describe the other cases. The case you mentioned, ACLU versus NSA, right, and some 4 dozen other cases were thrown out not because the government refused to let the plaintiffs used classified information that they had, but simply because those plaintiffs couldn't prove that they were subjected to surveillance. In many of these cases, the theory of standing, meaning you were victimized by the program, you have the right to sue. The theory of standing was that the plaintiffs had a legitimate fear that they were being subjected to surveillance, for example, because they were journalists covering international events.
Right.
That's why those cases were thrown out, simply for lack of standing.
Right, but that lack of standing came from their not having the documents to prove that they were being surveilled, and they didn't have the documents to prove that they were being surveilled because the government refused to give them to them.
Precisely. Now our situation was something different. In 2004, during the investigation of Al-Haramain by the Treasury Department to determine whether there were any purported ties to terrorism, the government accidentally gave our clients a copy of a top-secret document that we contend revealed their surveillance. Once we sued, we battled for 3.5 years over whether or not we would be permitted to use that document to prove the surveillance, to show our standing. Right. Finally, in the middle of last summer, Judge Walker said, tell you what, let's put the document aside. Plaintiffs, I want you to make an attempt to prove your surveillance based on public evidence. And so that's what we did. And the statement you're referring to by the FBI deputy director, that was made in 2007 in a speech that the deputy director, John Pistoli, gave to a group of bankers that was subsequently posted on the FBI's website, in which he actually not only admitted, but I would almost say boasted, right, about the surveillance of Al-Haramain.
So we have a minute left here, John Eisenberg. Bottom line is that if you have been wiretapped by the government, the only way, or otherwise intruded upon illegally, the only way that you can ever successfully sue them to stop it is if somebody from the government brags about it in public stupidly.
Well, if you can somehow put together evidence in the public record showing that you were surveilled, then you have a lawsuit. I would say that probably this case, Al-Haramain, is the one and only case where that's going to happen.
Yeah, which means that everybody else who is the victims of illegal behavior, criminal behavior by the Bush administration, has no way to demonstrate that, and the Bush administration will not be held to account.
True, but they are held to account now because this judge has said this program was illegal, and that is hugely important because now we have a judge, right, in the judicial branch of government.
Do you think that this will go to the Supreme Court, and if so, do you think the 5 right-wing justices will strike it down real quickly?
It depends on whether or not the government appeals this decision. I think they would be well advised not to.
Yeah, very interesting. Very interesting. John Eisenberg, EANDH law.com, his website. John, thanks for this.
Thank you very much.
Thanks for dropping by and informing us about what's going on here.